Hello students, how are you? I hope you are doing well. So today we are going to talk about a different topic. So far we are going in sequence from the history of the Companies Act, then we moved on to the features, the disadvantages, various types of companies, how company form is different from the other business entities. Then we in the last few sessions we have studied about the incorporation provisions and the role of the promoter. Now, once the company gets incorporated, okay, it has to be the business of the company has to be conducted within the limits of the within the powers. Where are those powers given exactly? So those powers are given under Memorandum of Association. So yes, our today's topic is Memorandum of Association. We have briefly talked about the Memorandum of Association when we studied the incorporation process of the company. But now let's go into the detail of what is exactly meant by Memorandum of Association and what are its contents. And then if in future company wants to make some alterations in the Memorandum of Association, whether company can do it. If yes, how company can do it? So all these topics we are going to talk in detail today. So let's get started. So let me just put the Memorandum of Association heading over here. Memorandum of Association. Memorandum of Association. I will use the short form for the convenience, that is MOA. So please don't get confused when I will say MOA. It is nothing but Memorandum of Association. So what is MOA exactly all about? So MOA is a kind of document which sets out the constitution of the company. And that we can call it as it's a kind of foundation on which the company's business is built. So it defines the scope of company's activities and its relation with the outside world. So where exactly, let's try to understand where exactly the Memorandum of Association is defined. It is defined under section 2, subsection 56. So it talks about the definition. Let me just put the definitions over here. So the definition is given like this. Memorandum means the MOA. I'm using a short form for the convenience purpose. MOA of a company as originally framed or altered from time to time in pursuance of any previous company law or this act. So see the definition which is given under section 56 of the act, which says that what is mean by memorandum. It means the MOA of a company. This is the first part. As originally framed. So what is meant by as originally framed? So when a company goes for incorporation, we have seen that this is one of the steps where company has to give its draft MOA, draft AOA, which is duly signed by the subscribers. So that is originally framed. or altered from time to time. So it is not a rigid document, it may be altered from time to time. As I told you, there is a procedure laid down in the Companies Act 2013 where you can go on altered, you can keep on altering the provisions of the memorandum as per the convenience of the shareholders. So we will talk in detail. In pursuance of which law? In pursuance of any previous company law or this act, means the erstwhile company law, that is 1956, or this act, that is Companies Act 2013. So this is the definition, okay, which is given under the section 2 subsection 56 of the act. Now let's try to understand what can be the importance, okay, important points regarding MOA. So generally, why the MOA is very important? So we can say that the importance of the MOA. So let's try to understand in detail. So I'm just putting, okay, importance of MOA. Importance of MOA. Okay, so which can be the points for importance of MOA? So if the separate question is asked, what is importance of the MOA, you can write down few pointers. Okay, we have not yet started the corresponding provisions given in the Companies Act for MOA. So first let's try to understand why it is so important, why the importance given to this particular document when a company is going for the incorporation. So let's quickly try to understand. So MOA is considered as it is the charter of the company. It is a charter of the company. One by one, first we will write down and then we can go back and we can discuss all these points in detail. It contains fundamental conditions. It contains fundamental conditions upon which company is incorporated. It contains objects of the company. It contains objects of the company. The company has to act within objects specified in MOA. Company has to act within objects specified in MOA. It defines powers of the company. It defines powers of the company. So anything done beyond the objects specified in MOA will be ultra virus. it should be printed and divided into paragraphs and numbers. Should be divided into paragraph and numbers. It should be signed by the subscribers. It should be signed by whom? It should be signed by subscribers. So these can be few important points relating to the MOA. So let's talk one by one. Let's talk in detail one by one. So when I say MOA is a charter of the company, what do you understand? So charter means the constitution. So it defines all the powers of the company. So MOA is a kind of constitution like our country, India. We follow the constitution of India. How the prime minister should be appointed, president, we get the fundamental rights, fundamental duties are there, everything is properly specified in the constitution of India. In the similar way, when a company is to be run or company has to conduct some business activities, it should have some kind of charter, it should have some kind of constitution, and that is nothing but the MOA. So MOA defines everything about the company. It contains fundamental condition. So there are various different clauses in the MOA. The question can be expected, what is MOA and contents of the MOA. So contents of the MOA are defined under the Companies Act. So contents of the MOA will remain the same. Of course, the description will differ from company to company, but the structure of the MOA remains the same throughout, for all types of companies. It contains objects of the company. This is the very important point, to be noted over here, because the MOA defines objects. It gives a clear idea to the outsider when he is going to deal with the company, whether company is acting within the objects or the powers given under the MOA. So by reading the object clause of the MOA, one can definitely find out whether the powers are given to the company for doing this particular transaction. So one need not ask everyone, whether company is empowered to do that or not. He can just go through the MOA, and it is always presumed that outsider, when he deals with the company, has read the MOA carefully. The company has to act within the objects. So this is the connected point. Can company go beyond the objects? If you are not given any authority, and if you go beyond that authority and do that particular task, whether it will be valid? Of course not. The similar way, company has to act within the objects specified in the MOA. Now the question will arise, whether company's objects can be altered from time to time. Definitely yes. So company's object clause also can be altered, but there is the procedure laid down under section 13 of the Indian Companies Act 2013. It defines powers of the company. So it defines powers of the company, how which particular powers are there to the company form of business, under which particular what can be the powers up to till which extent company can function. So everything can be properly defined under this document MOA. Anything done beyond the object specified in the MOA will be considered as ultra virus. Now what is meant by ultra virus? Here the meaning of ultra is beyond and virus means powers. So anything done beyond the object clause of the MOA will be considered like it is the act done beyond the powers. So company cannot function beyond the powers. That one has to keep in mind. It should be printed, divided into paragraphs and numbers so it is just for the convenience purpose, it is properly defined. The contents of the MOA should be properly defined in the booklet. It should be properly divided into various clauses like name clause, capital clause, register office clause, which we are going to talk little later. It should be signed by whom? It should be signed by the subscribers. Now subscribers are the persons who are the first shareholders of the company. In case of the private limited company, we have minimum 2 shareholders. We require minimum 2 shareholders, and we require minimum 7 in case of the public limited company. So these subscribers, they will have to sign on the MOA. So this is what all about the important points. Now let's talk about Memorandum of Association contents. Okay, so I'm just putting over here contents of MOA. The provisions are given under section 4 of the Act. First, let me just write down which all contents are there. So there are totally 6 clauses. This question is very important from the exam point of view. Question can be asked like define Memorandum of Association and its contents, or define Memorandum of Association along with the important clauses. So there are 6 clauses in the Memorandum of Association. So which all those clauses? Name clause, then we have register office clause, name clause, register office clause, then we have object clause, register office clause, then we have liability clause, capital clause, and last one is subscription or association clause. Okay, let's talk about all these clauses in detail. So what is the name clause? See, the name of the company is very important. The company business form is identified by its name. In the process of incorporation, we have discussed about this name clause. If you remember, under section 4.2 of the Companies Act, the company's name should not be identical or similar to the existing companies which are registered under the Companies Law. That is the first point you need to keep in mind. Company may not just directly write down the names of the central or the state government while going for the incorporation. At the same time, if the company is violating or contravening the very important act, one act is there, the name of the act is the Emblems and Names Improper Use Act. Okay, if the company is using the names which are prohibited, so if the names which are prohibited under this act and the company is using those names, then also it is not allowed. So what is the procedure for the name, to getting the name of the company? First, the proposed company has to approach to the ROC, Register of Companies, for reservation of the name. So once the name is reserved, it is valid for the 60 days. And company may go for the further incorporation procedure, okay, along with that particular name. But does it mean that it will be a permanent name? Answer is no. The ROC may come up with the different name suggestion if ROC is not satisfied or is of the opinion that the name proposed by the company or reserved by the company is contravening the names which are already registered by existing companies, then definitely ROC may suggest to put some different name. Now, in case there is a trademark infringement, again the name of the company has to be different. Now, the name clause is very simple. It's not that difficult. Okay, it is not written in the different way. Like it is just written the name of the company is so and so private limited. So if let's take the hypothetical example, if there is ABC private limited, then the name of the company is Messrs ABC private limited. But there are certain other provisions which may not be incorporated in the Memorandum of Association. So, company should have its own identity. At the same time, wherever a company is operating, so let's say for example, the company's registered office is situated in Mumbai. So company's name should be displayed in English. At the same time, company's name should be displayed in the vernacular language as well. So like in state of Maharashtra, the vernacular language is Marathi. Along with the name, the registered office address should also be displayed. And very important, one should not forget the CIN number, which we have discussed in the process of incorporation. Company gets 21-digit unique CIN number, which should be also mentioned on the display board of the company. Now let's assume that company is having a registered office in the Mumbai, but company is also operating from Bangalore. Okay, in that case, company's name will be displayed in the vernacular language of the Bangalore, like Kannada in that particular case. So wherever a company will operate, company will have to disclose the name, okay, in the English as well as vernacular language. There is one more provisions. Whenever company is doing any kind of communication like letterheads or take any kind of communications, emails for that particular matter, okay, so company will have to disclose the CIN number, which is mandatory, along with that the website of the company, if company is having any kind of email ID and all that. If company is contravening with these particular provisions, then company will have to pay the per day penalties as prescribed under the Companies Act 2013. So the contravention is not that easy. One has to bear the contravention in the form of penalty. Again, if the company is going for alteration of the name, I am going to come little later on that particular point, but before that I would like to highlight here, if company changes its name, then for next 2 years, company will have to display the former name as well. So let's assume that if company had changed name from Messrs ABC Private Limited to XYZ Private Limited, in that case, company will have to disclose the fact of that company's former name was known as ABC Private Limited, because the outsider should come to know about the company, and that is the reason, outside should come to know that earlier this company was called as ABC Private Limited. So that is a reason, such type of provisions are there in the Companies Act for the name clause. I hope this name clause is very clear to you. It is not, all these provisions whatever I have discussed may not be incorporated. It is just for your understanding, and yes, you have to write down in your answer. The name clause is very simple in the MOA. The name of the company so and so, like that. Let's talk about the second clause, that is register office clause. Why one requires register office? For the communication purpose. So company should have one register office. So as we have discussed in the process of incorporation, if you are aware and if you remember, we have talked about the company should have the register office. But in earlier Companies Act 1956, there was the mandatory provision that at the time of incorporation, company should have. But now in the 2013 Act, company may even be incorporated without having the registered office at the time of incorporation. So in that case, what company will have to do? Company will have to get it registered, and then within the 30 days from the date of incorporation, company will have to have its own registered office. It may be a rented premises as well, but after having the registered office within 30 days, then the company will have to inform to the ROC with INC 22 form. So now how this clause is drafted in the Memorandum of Association. Under Memorandum of Association, the registered office clause is written like this. The registered office of the company is situated in will be situated when you are going for the new incorporation. You will mention that, okay, if I do not have the registered office right now available, I will just mention that the registered office of the company will be situated in the state of Maharashtra. If you are having the registered office, very well, you can mention the name of the registered office. Okay, so registered office is having its own importance in the Companies Act. All the statutory registers should be maintained at the registered office. If companies then altering the register office, there are some stringent provisions, lengthy procedure is there when company goes from one state to another state. We will talk about little later when we will discuss about the alteration of Memorandum of Association. I hope this register office clause is also clear for you. Next clause is object clause. I will mark a little bit of star to this particular point. The reason is I feel this is the most important clause in the Memorandum of Association. How this becomes the most important clause? The company, what company can do, what company cannot do, everything can be written in this particular clause. So if an outsider wants to deal with the company, it is always advisable for the outsider to first know the contents of the memorandum. So there is the principle of the common law principle under the Companies Act, okay, which says that the outsider is presumed to know the facts. Outsider is presumed to have that constructive notice when he is dealing with the company. So what a company can do, what a company cannot do, and if he doesn't read the contents of the object clause or the memorandum, then he cannot say that, cannot take that defense that I was not aware about the objects of the company. So he has to first get himself, he has to first know the contents, and then only he should proceed further. Now how this object clause can be written? So there is a practice under the old act, okay, object clause is written in three different, it's a bifurcation. So first one is main object, ancillary object, and we can have other objects. What can be main object, ancillary, and other objects? Under Companies Act 2013, you can straightly have, you can write down all the objects as it is. There is no need of bifurcation, but still it is advisable to have such kind of bifurcation in the object clause. The reason is one should know what are the main objects of the company, what are the ancillary objects and other objects of the company, because it is very easy then to identify, okay, what can be the main object. So let's take example, if I take example of the TCS or Infosys for that matter, these are the companies which are into the information technology, as we all know. So these companies do business of some software developments, or this company may be doing some business relating to the IT field. So this can be the main object of the company. Just to give you an example, if a company is into the manufacturing of furniture, the wooden furniture, the company will mention its main object like this. Company is in the manufacture of wooden furniture, including the doors, windows, or whatever furniture company will manufacture for that matter. Then what is the ancillary object? Ancillary object means the objects which are connected with the main objects. So like one can have the ancillary object which is connected with the main object, like just to give you another example. If a company is into the manufacturing of medical devices, you can have the ancillary object which is connected with your main object, like to provide the paramedical services by the company, okay, and other objects are also equally important. In other objects, you will mention what a company can generally do. Like company may have to borrow the funds, company may have to enter into bill of exchange or any kind of negotiable instrument in its own name or to contracts for that matter. Company can lend money, so forth and so on. So there can be so many other objects. Let me tell you students, this is going to be a very lengthy, this is one of the very lengthiest object you can say, lengthiest clause you can say in the Memorandum of Association. Okay, in many Memorandum of Association you will see this clause is written in pages. One has to be very careful while drafting this particular clause, because one has to be keep in mind, okay, in future what will be the requirements of the company. You cannot just have a clause written in layman's language. You have to first beforehand think what a company can do in future, what are the expected business, okay, in the name of the company, and accordingly you can frame the main clause, which is very important. So this drafting of the main clause is very crucial, okay, because it may lead to a lot of disputes, because again and again you cannot go and change or alter the object clause of the company. It is not at all feasible, and that is the reason one should be very careful while drafting the object clause. And let me tell you, this object clause will determine what a company can do and what a company cannot do. So if anything is done beyond going the object clause will be treated as ultra virus, and that transaction may be treated as void, which is against the law. So why to take that particular risk? You have to have the very beautifully drafted object clause. Otherwise it will lead to unnecessary disputes in the name of the company. Okay, I hope this object clause is very clear. We are going to talk little later about the, I think in few next sessions I am going to talk about one of the very important doctrine relating to object clause. The name of the doctrine is doctrine of ultra virus. What is mean by ultra virus? Beyond the powers. Company cannot function beyond the powers. So which is directly connected to this object clause. So company cannot do a business which is not defined in the object clause. So company has to work within the framework or the powers which are given under the object clause. So it is very important clause, okay, of the Memorandum of Association. Next clause is liability clause. I hope you remember we have talked about this liability as well, okay, when we have studied the earlier part. So liability can be again in the two ways, limited by shares. I am just here putting down the liabilities, limited liability, because this is one of the very important feature, and limited by guarantee. Limited by guarantee. Now how this liability clause is basically drafted in the Memorandum of Association. It is in very simple line, one-liner clause you can say. The liability of the company is limited by shares, or the liability of the company is limited by guarantee. So what is limited by shares? Let me again explain to you. The limited by shares means whatever is the liability of the shareholder, it will not go beyond it. So the liability of the shareholder will be limited to the extent of unpaid capital. So if he has already paid entire money for his shareholding, then his liability will be nil. But if he has paid only the application money and the call-on money he has not paid, then his liability will be restricted to that particular part. But if it is a guarantee, if it is a guarantee, then what will happen? Whatever the guarantees he has undertaken under this particular clause, so guarantees in case of the winding up, relating to the assets and liabilities, so those particular the liabilities will come on the shareholders. So this is divided into limited by share and limited by guarantee. Now let's talk about the capital clause. So what is meant by capital clause? Capital here is basically the authorized capital. So capitals are of different types. So capital can be authorized capital. Here we are going to talk about the authorized capital. Now what is the authorized capital? Authorized capital is the maximum capital which a company can raise. Okay, so companies authorized capital can be the maximum and the paid up capital can be different. So let's take an example where ABC Private Limited is incorporated with a authorized capital, with an authorized capital of 1 crore rupees, but its paid up capital is, let's assume that rupees 75 lakhs. Okay, so up to 1 crore company can issue the capital. Always remember students, authorized, the paid up capital can never be exceeded to the authorized capital because authorized capital is the uppermost capital. So if ABC companies, ABC Private Limited share capital is 1 crore rupees and if the per share value is rupees 10, then this capital clause will be written in this particular way. Like an authorized capital of the company is rupees 1 crore divided into 10 lakh equity shares of rupees 10 each. So in this way the capital clause will be written. So authorized capital, I hope it is very clear to you. It's a very again simple clause, and whenever as and when the company will require to issue the new capital or raise the capital, company can definitely go for this type of capital process. Okay, the increase of the authorized capital process in the case of through the alteration provisions. Last clause in the memorandum, subscription or association clause. As we all know, okay, to form we have already studied under the process of incorporation. To incorporate a private limited company, you require we require two minimum shareholders. For public limited company, you require 7 minimum shareholders. So they are called as subscribers. Their details are required to be properly given to the ROC at the time of formation. So subscription clause talks about those subscribers. Their details are mentioned. Whoever is the subscriber should be mentioned properly in the subscription clause. It is mandatory that subscriber should hold at least one share in the company. His details like name, surname, occupation and all other details, if it is the body corporate, then the body corporate registration number, as well as along with the subscribers, witness has to attest it, and that is the reason witness details are also required in the subscription clause. This is the clause which may not be amended from time to time. The reason is this is one of the clause which cannot be just the company cannot just keep on amending in future, and that is the reason even if the subscribers in future will transfer its securities to the outsider, then also if they are not the members of the company, the subscribers names will be mentioned in the memorandum and articles till the time company is there into existence. So one has to know the provisions relating to the subscription clause as well. It is also known as association clause. Please don't forget that. So these are the 6 very important clauses. If the question is asked or define memorandum, you need to define memorandum as defined under section 2 subsection 56 and then all these clauses in detail. Okay, so let's quickly write down all the notes. First we discuss about what we have covered, memorandum of association. Please write down these particular notes in your notebook. I hope you have written this. Then we talk about importance of MOA. Just write down all these pointers. So it is a charter of the company, fundamental conditions. It talks about then objects is defined, Then the within the object is has to work, powers are defined for the company. And we have already discussed ultra virus concept in detail. Okay, but yes, okay, we are going to study this doctrine once again. Then it should be printed properly, divided into different paragraphs and numbers. It should be signed by the subscribers. Then contents of MOA. Six clauses are there. Please do not forget. Okay, there are 6 clauses. Name clause, register office clause, object clause, liability clause, capital clause, and subscription or association clause. Don't forget that. I hope all these concepts are very clear to you. Now let's talk about the next topic of this relating to MOA only. Alteration of MOA. The provisions are given under section 30. What is alteration of MOA? See, once the company gets incorporated, that does not mean it will never, it may never alter or make changes in the MOA. From time to time, as company grows, company may have to alter or make changes in the MOA. There is one clause which may not be altered, which is that clause? Subscription clause. But all other clauses can be altered from time to time. But there is a process laid down. One should follow that process, and then only company may go for the alteration. So let's talk about one by one the clauses. So if I say that alteration of name clause. So which all points will come over here? So can board of directors alter the memorandum? Answer is no. Only in one case, board of directors can pass the resolution to alter the memorandum. But in rest all cases, majority of the cases, the shareholders will have to pass the special resolution to make the alterations in the Memorandum of Association. So which all points you can say? The first is special resolution you will require. Then special resolution you will require in order to change the name clause. But if the company is changing its name, along with the special resolution, approval of central government will be required. Third is, if company is changing its name from private to public, then no need of CG approval. What does it mean? So if a company is going to change the private to public limited, because as and when the company grows, there are many examples where the company was started. Take example of the Infosys Technologies. So when the company was started, it was a private limited company, and later on the company name company status was changed to the public limited. It became the listed entity, and it is one of the largest listed entity in India. So in that case, your name of the company what will be the change? Like ABC Private Limited is changing to ABC Public Limited or ABC Limited. So that is the only change for which you do not have to obtain the central government approval. But yes, you need to pass the special resolution. And then at the same time, there are two types of resolutions, special and ordinary. Ordinary is basically the simple majority, special is super majority. So persons who are present, members who are present and voting, accordingly the resolution will be passed. Approval of the central government will be required, because you cannot just go on changing the names all the time. That is the reason the approval of central government provision is there for the change in the name of the company. Again, after alteration of the change of the name of the company, as I told you, for the next 2 years, company will have to display the former name in each and every communication, at the same time display on the board of the company. Because the outsiders, those who are dealing with the company, they should be aware that company's name has been now changed from the old name to the new name. Second alteration is with regards to alteration of registered office clause. So registered office, there are three situations. Okay, either the company may change its registered office within local limits, isn't it? Or company may change within state, or third case is from one state to another. Now all these three types of changes are treated differently. So when the company's office is to be changed within the local limits. So take example, company's registered office is situated within Mumbai, and within Mumbai itself it is going to change. Then you will require only the board resolution. So board resolution is sufficient, because it's not going to make so many changes for the status of the company. But when it is the matter of change from one city to another within one state, then you will require special resolution. Then you will require special resolution plus RD approval. Okay. And then if the company is going to change its register office from one state to another, again this is not going to be an easy task. Why? Because the creditors who have given the loans to the company for any matter, like banks and all those, they had given the loans in, anticipating that company's register office will be there. Okay, but in such a case, company cannot just go and take away everything from one place to another city. Okay, like Mumbai to, let's assume that Kolkata. It is not going to be an easy task. In this case, again the special resolution will be required plus CG approval. At the same time, as I told you, CG will ensure that creditors' consent has been obtained, and CG, the central government, has to get it satisfied. So it has to be satisfied that the register office clause can be changed, register office of the company can be changed from one state to another, and there is no harm, right? Liabilities will not be affected and everything. And that is the reason there is a process of getting the creditor's approval in case of change of register office clause. So this is one of the clause while making the alteration is quite difficult under the MOA. Of course, it is not that difficult within local limits or within state. But yes, it becomes really difficult when a company is going to change its office from one state to the another state. So it is always advisable when a company is going to be formed, company will have to first think, promoters or the subscribers for that matter, they will have to first ensure that whether they are going to change the office in future, and if it is yes, then they will have to think accordingly. So this is one of the very difficult alteration, you can say. The third alteration which can be made in the alteration of object clause. Alteration of object clause. So what you will require in alteration of object clause? Of course, you cannot just change object clause with ordinary resolution. So you will require special resolution. Special resolution is passed by shareholder. At the same time, if there is any unutilized funds, okay, then the dissenting shareholders should be given an opportunity to exist. In case of should be given an opportunity to exit. So under the alteration of object clause, one has to pass the special resolution. So it is always done, okay, by passing the special resolution. Now if company has earlier taken the money from the subscribers and company has not utilized all the funds, it means the unutilized part of the amount is there lying in the accounts of the company, and still the company is going ahead with the change of the object clause. Then it will be an injustice to the earlier shareholders who in the belief that okay, the company will utilize those funds for the object specified earlier, okay, but it is not happening now. So in such a case, the dissenting shareholders, whoever are the dissenting shareholders, should be given an opportunity. So they will be given an opportunity that okay, they can change, okay, they can go away from the company. So then exit opportunity has to be provided to the dissenting shareholder. Rest all other things company can do, okay, after alteration. Then alteration of liability clause. Alteration of liability clause. What is alteration of liability clause? So company is changing this liability from other, like limited by shares to limited of guarantee, like that. Of course, you cannot do so without passing the special resolution. Along with passing the special resolution, whenever you will make such changes in the clause, you will have to okay, intimate to the ROC for that matter. And the last is alteration of capital clause. What is meant by alteration of capital clause? So if company is raising the authorized capital, company is raising or increasing the authorized capital, okay, the special resolution needs to be passed. Special resolution will be required. It's not a special, okay, I missed it. It should be an ordinary resolution. So this is the only case where okay, ordinary resolution will be passed and will be sufficient. Because see, when a company is increasing the capital from let's say 1 crore to 2 crores. So if the company's paid up capital is 75 and your authorized capital is 1 crore, company requires 1 more crore of the capital. Company cannot do so without altering the authorized capital clause. That is the capital clause of the company. So company will have to just pass the ordinary resolution, simple majority is sufficient, and then company can do so. So these are the alteration processes. Remember students, once you go from these alteration processes, after going through it, in the MOA, the date you alter this particular provision should be mentioned at the bottom of the MOA copy. Why? Because for all future references, whenever there will be, okay, whatever changes have taken place from the date of incorporation, okay, till that particular day, the reader should come to know, even the ROC, whatever changes have taken place, everything should be properly mentioned on the MOA copy. So like for example, let's assume that company has increased the share capital, authorized share capital from rupees 1 crore to 2 crores. The company will mention the authorized share capital is increased from rupees 1 crore to 2 crore as per ordinary resolution passed during so and so meeting dated so and so. So this is required. Okay, this is a procedure given under the Companies Act. So these are the alteration procedure. The company may not just function if it is a rigid process, and that is the reason alterations are so important. Alteration for subscription may not be possible because as I told you earlier, you cannot change the subscribers later on because they are the original subscribers. You cannot change them. So alteration of subscription may not come. But yes, you can definitely write down all this procedure. Please make a note of all these provisions. So alteration of name clause, special resolution, central government approval is required. It is not required for private to public. No need of that approval. Within local limits, if it is there, registered office clause, your board resolution is sufficient. If it is within state from one city to another city, special resolution plus RD approval. And from one state to another, you will require special resolution plus CG approval, that is central government approval. If you are going for alteration of object clause, you may not just require you will not just require only the special resolution, but if the unutilized amount is there, make sure that dissenting shareholder should be given an opportunity. Alteration of liability clause, special resolution is required, and you can alter the liability clause of the company. And alteration of capital clause, only an ordinary resolution is sufficient, and there won't be any alteration process for subscription clause. So students, today what we have learned about Memorandum of Association, the definition of it. Then we talk about the importance of the memorandum, various points we discuss, like it is a charter, fundamental document, conditions are very important. Then the object of the company, it should act within those objects. It will always prevail, printed, divided into paragraphs. Anything done beyond the memorandum is ultra vires subscribers. Then we discuss about the contents of the MOA. So 6 contains 6 clauses, very important question from exam point of view. Very likely to ask for full length question. Name clause, register office clause, object clause, liability, capital and subscription clause. And the last part we have covered, alteration of Memorandum of Association. So I hope, okay, all these points are very clear to you, okay. And from the exam point of view, this question is again very important. It may be asked in the case studies or full length. The various clauses may be differently asked for the short notes and all those questions. In all such questions, this document is really very important. One has to be very careful while drafting this document. So as this is the primary document, very important document, the subordinate part of it, that is the subsidiary document regarding the rules regarding articles of association, we will discuss in the next lecture. So students, thank you so much for attending this lecture. Do watch this video, and if you have any doubt, okay, you please read the notes as well and watch this video again. Thank you so much for attending this lecture. Till then, goodbye.